Great. Thanks to everybody for, is this on? Yeah. Okay. Thanks to everybody for being here. It's a great pleasure to have the opportunity to introduce and moderate this panel. I will say I was happy to hear some discussion at the University of Chicago because early this morning I was just spending time looking up everybody's bios to see do we actually have a majority of speakers here who went to the University of Chicago for law school, but it's not quite that, but it's a very strong plurality. That's what
you have a glass?
One of the interesting notes about today. But in any event, I'll just give brief introductions for the panelists, then we'll probably start with Rick because I think his subject matter follows most directly in relation to what we had on the last panel. So Rick is basically just to say where people are professors in some areas. So Rick is a professor at the NYU School of Law, and he's an expert. I was going to say, well, I guess I'm going to say it. I was going to say sort of an expert in law and economics, but I crossed that off after that was seemingly verboten, but we'll see if that gets some flack. But also just more generally an expert in private law, including maybe particularly contracts and corporate law, which and certainly the last part is reflected in his paper for today. Andrew Kull, who was a colleague of mine here for a number of years before he sadly retired last year, and now I'm learning property law from him, reading the case materials he put together before I try to teach that for the first time in the spring. Before that, he was a professor at, if I remember correctly, Boston University and Emory. And of course, has reflected substantially the materials for today, or was the reporter for the Restatement Third on Restitution and Unjust Enrichment, in which he worked closely with both of the Dougs who are represented today, Doug Laycock and Doug Rendleman, who's also on our panel. Doug Rendleman is Professor Emeritus from the Washington and Lee. Has been one of our leaders in the remedies field as well. Actually, I believe the ALS remedies section's first distinguished sort of legal scholarship career award was to Doug Rendleman, and then the second was to Doug Laycock. And when I introduced that award, I think I tried to emphasize this award isn't only for people named Doug, and hopefully that'll be reflected in whoever gets it as the third awardee. Doug Rendleman, among other things, is a casebook co-author, I believe, with Caprice Roberts, who's our fourth panelist, who's one of our leading remedy scholars these days, has also worked with Dan Dobbs, and what's kind of our leading sort of remedies treatise materials. Both of them are experts in restitution, among other things. So with that, I'll turn it over to Rick, and I'll just sort of signal as you get to having 5 minutes left out of the 15 maximum you're supposed to use.
And I'm going to set my watch alarm. I'm going to try to do 10 because I'm much more interested in hearing from you guys. So it's really just to give you a qualifier on where I am on law and economics. I'm actually in the process of writing an article called "Law and Economics is Dead," and I've always been skeptical of some analysis. I did something called the efficient performance hypothesis to contest the notion of efficient breach. And it's a good time for me to write. I'm the president currently of the American Law and Economics Association, so they can't kick me out at the moment. So we'll see how that goes.
You don't want to consider calling it the death of law economics?
That brings me to the second point. So the article that I submitted it late. Apologies to everyone. Already I see all these things that I want to change about it, and one of the most important things is where the title comes from. I have a line that says presumably influenced by Grant Gilmore, Doug chose the death of contract, but I just learned that was not the source, and that it might have been called the scattered remnants, which I think is beautiful and really wonderful, and kind of what I want to say a little bit about. So if we can think of the irreparable injury rule as in various stages. In the first stage, it's born in battle, the battle between law and equity and the compromise that we ultimately get, which is the irreparable injury rule. And then Doug describes its death, or its scattered remains. And I see four really key points that came out of the article. I read it 100 times as a graduate student in the economics department when I just started. It was a real guidepost for me. The first thing is that it's not one rule, it's many different rules. The second is that plaintiffs get it when they want it. The third is when they don't get it and they want it, there's some other reason, the real reason, and that's what we should be inquiring into. And the fourth is that this confusion is costly, the lack of clarity. I'm just going to talk about the first two. It's many, not one. And I wanted to ask if there's something special about contracts. Is there something about contract law that's special? Maybe this does push against the trans-substantive. I teach contracts, but I spend the first month on remedies because I know I'm going to run out of time. But I think a lot of contracts teachers do that just for that reason. And I do think it's the collapsing number of credits that's causing it. I agree with you, Reg. Okay, so there's the birth, and then Doug describes the death. I think there's an interesting rebirth of the irreparable injury rule in the country. And it's described, maybe not accurately, but it's described by Morton Horowitz as the transformation of American law. And Horowitz says, something happens, and I have this wonderful quote. He says, he describes what he calls with the recognized death, because, like Doug said, the death probably started, but it was going by the Elizabethan period. It was the remnants were being scattered by then, if not. And in the colonies, in the American colonies, the British American colonies, the contracts were really thought of as a species of property. And so and what was awarded was specific performance, and also it was also grounded in a notion of just price. So restitution and justice were the principal remedies in this moment in the colonies. And then says Horowitz, something happens. Something's going on in America that's transforming the law. And one thing that happened, he says, is that it begins with breach of stock contracts, and the courts they start ordering damages. In fact, they start ordering expectation damages. And he has an account of sort of the exigencies and the urgency of commercial moving from the farmer landed model of really kind of this title notion of contract into a commercial where expectancy becomes, your expected interest in the transaction becomes dominant. This is what causes, I think he doesn't use these words, but I sort of interpret it as a rebirth. The rule was dead. People were getting restitution and specific performance for breach of contract, but then we move into this domain. And Brian Simpson writes like a really powerful critique of Morton Horowitz's point. They disagree, mostly methodologically. But Wilson says, just describing this rebirth, the moment at which courts focus on expectation damages rather than, this is a quote, restitution and specific performance to give a remedy for non-delivery is precisely the time which contract begins to separate itself from property. So that's really fascinating. So then we get this rebirth. And I also think that the next section, I'm going to call it dead again, because I think it will die again. But this is making me wonder, is there something distinctive about contract? Doug concedes that there's one place, and at lunch you mentioned it again, there's one place where this, the adequacy, reparability claim does work. In a market where with fungible goods and services, yeah, that's, so it might be that this is the place, and this kind of market, the rule works well. There might also be a kind of reverse causation or causality or co-creation, that if you want to have a fungible, fluid market, maybe you need to have a rule that moves away from the deeper considerations and just give money damages. And yeah, it'd be nice if you calculated it correctly, but we can limit it and train. So we get these forms that limit it, but it may be something that creates the market, not simply a reaction to the market. So I'm kind of interested in that, and that's one of the things that the chapter is going to work out. But again, there's just something, I'm wondering now, is there something distinctive about contracts? So the same year that Doug tells us that the restatement second of torts expresses disfavor for the rule. That same year, the restatement second of contract doubles down. Alan Farnsworth says that our tradition has been not to give specific performance, and of course he's clearly being influenced by the law and econ guys around him. He's citing, if you look at the reporter's notes, it's full of, I'm sure somebody told him to put that deep in the reporter's note and not in the, but it's also in the introduction of the chapter. So there's something normative going on there on the law and economic side. So that's all to say that maybe there's something going on, and maybe it's justifiable. I don't want to make a claim about that. There's something distinct going on in contracts with the irreparability rule. Now, very recently, there's been this great judge, Katie McCormick, a chancellor. She's the chancellor of Delaware Chancery. She's been a complete thorn in Elon Musk's side. When he when he changed his mind about acquiring Twitter, you guys might remember that summer, she basically sent him a letter to him and I'm going to force you to buy it. She said, because it's actually in the deal. I'm going to order specific performance. So you can try to back out. There's not been a material adverse event. You're not getting out. So she basically forced him to buy Twitter. And then later on, of course, she undid his salary increase because it didn't have a. So he's not a. But she's doing something really interesting, and she's also talking about something that's happening in Delaware Chancery and mergers and acquisition deals in particular, in some sense initiated by Leo Strine when he was when he was vice chancellor, that Delaware automatically gives, or there's a strong presumption of specific performance for breach of merger transactions when the parties put it in their contract. So you can have a contractual entitlement to it. I think that's not so new. It's kind of interesting. I think it's Doug's second big point. When the plaintiffs want it, they get it.
5 minutes.
Okay. I'm sorry. Okay, I'm going to give myself 1 minute. When the plaintiffs want it, they get it. And if they stipulate it in the contract, they will get it. So there's so that I just think that's interesting and important. I want to say the thing and the reason why there's a long appendix and which needs to be filled out, that was done by my excellent research assistant. And I liked it so much, I put her on as a co-author. But it was thanks to Sam. Because I did another paper, and Sam pointed out to me, you should look at the variation of the courts of equity across jurisdiction when they came up. Some of them, Doug, thank you for informing me in so many ways. Some of them had juries, which is super interesting, because I think there's something going on with the jury. I think it's the shutting. I think what Horowitz calls something like the economy or something else, I think there's something, kind of a displacement, or at least there's an elevation of jury trials at that time, and juries making decisions. And now, with arbitration and contracting, the jury has disappeared. What's really fascinating to me is that you can now get awards of specific performance for all sorts of things that you don't even, things that you can, and you can, I believe, get an order for specific performance of a non-compete in California, which doesn't recognize non-competes as enforceable. If you do it through arbitration, I think that gets enforced in California. So we're sort of coming back again, where you can actually, maybe this is the rebirth after debt again, where through arbitration agreements that are ultimately enforced, specific performance of all sorts of things can be done. And what's happening? What's the constant thread? There's something going on with the jury. The relevance of the jury. That was Simpson's critique of what he thought Brian Simpson, what he thought Horowitz missed. That thanks to Sam and you, Doug, that's been triggering me to think about how is the presence of juries play. What's the role of juries in this in the scattered remnants of the doctrine?
Okay,
thank you.
It's more than 2 minutes under time. So now we'll go to Andrew. We'll just have questions at the end.
Good afternoon. My paper is called The Fallacy of Discharge for Value. I am guessing that at least half the people in the room have no idea of what is referred to by that odd expression. And I think it's an interest. I think in 10, 12 minutes I can explain what the problem is, what the fuss is about, and persuade most of you that it's pretty interesting. But I mean, I'm going to do my best. I will try to start as if this was the first day of law school. You will see, if you look at it, that the idea is the third restatement of restitution and unjust enrichment did not handle this topic adequately. It was section 67, it's there. The conceit of my paper is to imagine that the American Law Institute wanted a restatement, fourth, of restitution and unjust enrichment, something that's not going to happen. And if someone asked me to draft a improved version, I would do this. And between the first page and the last of the paper, I tried to explain, what I would be trying to accomplish. Now, this topic, gee, how should you have done it differently? This would, you might reasonably seem both extremely parochial and also sort of self-indulgent on my part. I would justify talking about it in this way by the fact that first, if you read the restatement third, you can see that we were very uncertain about what we were saying. And at one point we say, well, here's the rule, but then again, here you could look at it this way, in which case that's totally wrong. Another thing is that at some point, Doug Laycock called me up on the phone, I think, sent me an email, and he said he really didn't like this so-called discharge for value. He wanted to write an article and repudiate the entire thing. And would I help him? And I'm afraid I discouraged him from this project, saying, well, it's, it's complicated and it's a lot of work, and Doug had a lot of other things to do, and that article was not written. So my thought now in this particular context was, I think I have better ideas about it than I did when we published that restatement, and I would give him a better answer today. And that's what this is supposed to be. So what are we talking about? Again, first day of law school, the basic idea, this is our first day of restitution class. Money or negotiable instruments, because we're in that world, very much commercial world, goes from A to B when it shouldn't, maybe there is a mistake, maybe there has been fraud, maybe there has been a breach of trust, all totally standard bases for restitution. B is unjustly enriched. A sues B in restitution to get back these are monetary assets. He's got a good claim unless B can show a defense. Now there's two potential ones. One is B says, hold on a second, restitution to you would be unjust to me because I have changed position, which is to say there's detrimental reliance. Like what? I spent the money on things that I would not have. That's a defense. I think it's easily recognizable equity thinking. It's just like estoppel. I would say it's the same idea. So if he can show change of position and unfairness to him, that's it. It's a defense to the claim. However, there's defense number two, which is what we're talking about. An entirely different and totally inconsistent rule, the one that they call discharge for value. If B takes A's money in apparent satisfaction of a valid debt to B by some third party, C, and in a minute I'll show you some examples of how that could possibly be, then B is going to say, I qualify as a bona fide payee or bona fide creditor, expressions obviously sort of by analogy to bona fide purchase. And as such, because of my creditor status, I have a defense to restitution, even if the assumption is I've had no change of position. It's just my good fortune that you gave me this money. This will be so even in the case where the defendant is obviously left better off than if the mistaken or fraudulent transaction had not happened. He profits as a result of the other person's, of the misappropriation. How do we explain the existence of these two absolutely antagonistic approaches to what has been a very common problem over the century? The main thing I tried to do here is to say, if you look further back than people are usually doing these days, you can see where they come from. And they become coherent, although antagonistic. I want to tell you one story that is good because it's the most sensational mistaken payment in the history of the human race. It happened only 4 years ago. You might easily have read about it in the newspaper, or if you have any interest in financial things and look at the websites and blogs and things that people do, you would have heard about it. It involves Citibank and Revlon. Revlon now bankrupt, at the time already insolvent, known to be. Citibank was a fiscal agent or whatever they called it. It was a syndicated loan to Revlon. Unlike the classic thing where the lenders are all other big banks, and I think there's a certain sense of noblesse oblige among them, most of these lenders were hedge funds. And the people on the other side of the transaction were hedge fund managers, and I think their responses are very, very different. So Citibank is told, okay, pay accrued interest to all of these people. Somebody pushed the wrong button on their payment software. I mean, this is a mistake that, if people are using human methods, writing things, talking, it's totally impossible, inconceivable this could happen, but they're not. It's complicated, and so there's a payment software, which everyone said was totally obsolete and with the worst user interface in history. But at any rate, 3 people for Citibank, 2 of them in India, 1 of them in Delaware, all double-checking each other, triple-checking each other, thought they were giving instructions to pay the accrued interest, and they discovered the next morning that they had paid all principal and interest outstanding to all of the lenders, which meant instead of $8 million, it was $900 million. And so they promptly told everyone, well, hey, we made a mistake and please send back the extra money. About half of the recipients did so. The other half said, hey, no, we've got the money and we're going to keep it. So the lawsuit is Citibank versus these lenders, versus these hedge fund managers, essentially, for restitution. They had not changed position in any way whatsoever. They said, we don't have to change position because New York law says that if you are a creditor and if you have a valid claim and you take money in, as I say, apparent satisfaction of that debt, your status gives you an immunity to restitution. To try to be brief about it.
6 minutes.
Okay, we're gonna abridge. It's a great story, but I need to tell you what happened with the Citibank Revlon. I mean, as I say, it's the most fantastic mistake in payment in history, and no comparison. I guess it was, there was a bench trial. It was in 2020. Southern District of New York, Judge Furman. This is the only thing I know about him. I think it's fair to say everybody expected that these guys would be ordered to repay the funds. No, he said they could keep it. That's interesting. That just means the guys who sent back the money were chumps, apparently. Yes. Now, this was eventually reversed in the Second Circuit, who said, to the extent this defense exists, and I'd say to some extent it does exist, you have to be without notice. And the circumstances here, this Revlon loan was trading in the secondary market between these banks at between 20 and 30 cents on the dollar. They're known to be insolvent. All of a sudden, you're paid all principal and interest way ahead of the maturity of the thing. Revlon bankrupt well before they matured. So the Second Circuit says, hey, listen, you had notice and there's no defense. Before they got it reversed, the lawyers who handle syndicated loan transactions in both New York and London had made their loan agreements even 10 pages longer than they used to be because they added these clauses that they were calling, this is what the lawyers named them, Revlon blockers, which apparently said, if you get money paid by mistake, you have to give it back. And I think that actually is quite significant the way that happens. Now, John is going to tell me I have only about 3 minutes to go.
4, yeah, 4.
4, okay. The Revlon story is too crazy to be a place to look for the law. It's just off the wall. But I said there is something there. And I can't give the details, but there is a leading New York case. None of this is that old. This stuff. I guess 1990 about. It'll be in the, where's the Remedies book? I bet you've got this one in there. It is the leading New York case. It is called Banque Worms, which is how they used to pronounce that bank. I don't think it exists anymore, but French bank. This is not so crazy as the Revlon. There's a bank customer, says transfer $2 million to recipient A, and the bank that is handling the wire transfer messes up, and they transmit it to recipient B. Now, apparently, both A and B are creditors of the bank customer, so they discover the mistake, send back the money. Now the stakes are very high because the borrower, the bank customer that started all of this, is now in Australia. They are insolvent. And so the fact that the payee got $2 million by mistake means that the payee has just avoided $2 million loss on the loan at the expense of the bank that pushed the wrong button. That's inequitable. There's no change of position there. But they said, hey, listen, we are a good faith creditor, and we didn't know, and we took this money in payment of the debt, and so we're immune to your restitution claim. Big New York litigation with two, I think, summary judgment, Southern District of New York, Judge Patterson, I believe. He came, well, the lawyers decided this, and the judge said, you know what? There are two rules in New York law about this exact situation. And there's lots and lots of cases. I mean, like I say, this is nothing new here. Wire transfers are new. I have to stop.
2 minutes.
Okay. There's lots of New York law. Much of it, the so-called mistake of fact rule, they say you have a defense if you can show you changed position and that restitution would be unfair to you. That's one. Then the other one was, now Judge Patterson says, well, there's what we're going to call the discharge for value rule. That's where this comes from. Where did he get that? He got that from the Restatement of Restitution in 1937, and it was not a good name, but he was referring to what is the tradition of case law that says if you're a creditor and you have a valid claim and you do not have notice of what has happened and you get money, as I say, ostensibly, apparently, in satisfaction of whole or partial of your debt, you can keep the money. So basically, Judge Patterson and the Second Circuit didn't see a way to really to find an answer in the New York cases. They certified the question to the New York Court of Appeals, and the New York Court of Appeals came back and said, we think that in this case we're going to go with discharge for value. Nobody called it that before this, but then they started to call it that. The best answer they gave, I think, is not crazy. They say the payee has to be confident that he can spend the money and not sit around. I think that's the best. Now, I will just summarize, if I may, in 1 minute. So what do I try to do in all the rest of this paper? Because there's lots there. I say, hey, listen, if you're trying to find authority for this in the 1937 restatement, you look a little closer and you'll see this is a chaotic mess. And it's very hard to see where the language came from and what are they talking about, and there's really no authority there. How is it, I mean, when the New York Court of Appeals decided this, they said, well, there's these two lines of decision, they're completely contradictory. How could that be? Why are there these two contradictory lines of decision, and where did they come from, and how are you supposed to choose between them? There's not a word about any of that in this leading case from the New York Court of Appeals, this Banque Worms. And I guess I would say, the best reason for reading this, if anybody ever wanted to, is that my idea is it's because they weren't looking back far enough. And if they had recognized that there's a long history, it's not just recent cases, gee, do you have to show change of position? I think that's the equitable defense. Is it enough to show that you're a creditor? Well, it turns out to be that's the thing that commercial lawyers thought up. If you're willing to look further back, I think you find that it used to be judges and lawyers were much more aware of this conflict. All through the 19th century, it was litigated all the time. There were two opposing camps, very well recognized, and it goes back even farther than that because the two alternatives are, I think, quite easily traced to into the 18th century. And my last remark, I think the charming thing about the history here, if you start looking at the older cases, is that on both sides, I mean, these two very different approaches, but they're like two rivers running in the side by side in the same channel, like the Mississippi and the Ohio, and you can tell them apart, but they're right here. I think it's not unreasonable to say they can both be traced to well-known 18th century decisions by our hero, Lord Mansfield. I mean, he states the best version of the equitable approach, and he certainly starts the ball rolling on the commercial approach. The ball is later picked up and carried across the goal line by Joseph Story, but that brings us into the 19th century. Anyway, I have to stop there, but I think it's kind of a fun topic.
Great. Thank you, Andrew. Well, from my perspective, you've earned expiation from steering Doug the wrong way to discharge for value. I will say the main thing I take about from this is I have something to talk about when I next see Judge Jesse Furman of the Southern District of New York, who clerked for Justice Souter when I clerked for Justice Breyer, and has helped add to the sort of sub-theme here of Supreme Court clerks or former Supreme Court clerks and their mastery of private law. So, anyway, so we'll move on where I think we're two speakers will divide the time. So I'll just signal to each of you when you have about 3 minutes left in your half of the time. And I think we'll start with Doug Rendleman.
Okay, thanks, John. Caprice and I worried and tried to follow what's in the restatement of restitution that's and the law of restitution that leads for creativity and restitution in new areas that where previously it had not been found. We plug Doug Laycock in here as a substitute for the restatement, which is the way we keep to our topic. And so it's the human tissue issue, and it's right now 1950, and we're in Baltimore, Maryland. And we're at Johns Hopkins Hospital, and it's a major research center. What they're looking for is human cells that reproduce out of the body. And this has not been going very well. Johns Hopkins is in the middle of a black neighborhood. A lot of the black people have come from the Deep South, and so it's kind of south up north. And there is a cancer of the cervix patient named Henrietta Lacks. And Henrietta Lacks comes in. She is, she doesn't have a bright future. Let's put it that way. She's going to die. Then the doctors at Johns Hopkins undertake an experiment. They have been undertaking this experiment, excising human flesh to see if it will reproduce or if they can get it to reproduce out of the body. And so Henrietta Lacks has cancer of the cervix. And she comes in for treatment. The treatment in 1950 was horrible. They would insert rods for radiation, things like that. And the Johns Hopkins team follows the way that they have been dealing with women cancer patients. And so without permission, without telling Henrietta what they're going to do, in their operation, they take cells off of her cervix. And now Henrietta dies just a few months after this. Henrietta's body dies. And they take these cells back to their lab, and success greets their efforts. Henrietta Lacks' cancer cells from her cervix reproduce themselves out of her body. It's a serious medical breakthrough. Johns Hopkins promulgates this discovery, and the cells, and they sell the cells, S-E-L-L, and Henrietta Lacks, and that's why they call the book about this is called The Immortal Henrietta Lacks, because these cervix cells are immortal. And it turns out to be a quite a lucrative operation. I don't had to use that word.
About 3 minutes, just saying.
Their company and others are able to sell these the cell line, and it's named the HeLa line. And if you talk to a bunch of lawyers, most of them will say, "I never heard of that." If you talk to biology professors, they say, "Boy, I talk about that in my class." It was robbery. It was immoral, incorrect, illegal, breach of fiduciary duty, tort for exceeding the permission she had given. And the HeLa line turns out to be very lucrative, and it's used today. You can buy it today. And this is the point at which I turn the summary over to Caprice. She's going to talk about the lawsuits. I've just talked about the Henrietta Lacks, black woman, not rich, not well educated, and an obvious victim at this point. She died soon afterwards, but the cell line lives on. Caprice.
Thanks, Doug. And I'm apparently going to be the last speaker of the whole day, so I'm going to try to do this as quickly and as I can. Please read our paper if you're interested in it. Obviously, the legal system cannot cure all of the world's ills, and we are definitely pushing in our paper to do something provocative perhaps beyond the bounds of what the restatement of restitution might have had in mind, if it's a thing. But we're happy to be sitting with many of the people that were so profound and involved in it. We were involved as well, but not to the great extent that Andrew Kull, who spent at least 15 years, and Doug Laycock, who was probably the most instrumental in that whole project. And the beauty of that is it revived the field, or maybe even created the field from the scratch, because it did so many things that are new to streamline the way that restitution law works. And so for me, it's a great honor to be here, to get to be a part of this, to have a paper about Doug Laycock. I got to also write one about Doug Rendleman, and unfortunately we did not get to have the in-person event. So it's really nice because of COVID, but it's really nice to be here as a part of Doug Laycock's event. And I've felt for a very long time I get to sort of stand on the shoulders of giants. At the same time, I feel like I'm screaming from a megaphone, because some of the things we're focused on are what I call the quiet corners of the law. But I think those corners are really, really important to think about sometimes very intricate things in private law, sometimes the way equity might be working, and trying to argue that equity has principles and that it is bounded. And then also trying to go back to doctrine. I feel very much a throwback sort of scholar in the way that I have to speak about restitution, because usually you have to be teaching for a long part of the article where you're doing the basics. And I think that's something that Doug Laycock would certainly appreciate. He wrote an article, many articles, but many on restitution in particular, laying out what the restatement does quite well in setting forth that this is not just an unmoored, unprincipled body of law, but it has a structure, it has a cause of action itself, as well as many, many remedies. And so for us, the interesting thing to think about in this paper, this is us being Doug Rendleman and I, or me, is the idea of using restitution in creative ways. And again, that's dangerous, that's provocative, because maybe lawyers will take it too far. And yes, lawyers will take it too far, that's what they do. I write a lot about other gain-based remedies and restitution, and this is one of them, where the plaintiffs are the lax estate, and they are trying to strip some of the profits from many companies who have made the billions of dollars that Doug was talking about. Just because those companies are making billions of dollars doesn't mean that they are evil, and it doesn't even necessarily mean that they should have to strip or be stripped of those profits, whether you call it disgorgement or some other type of taking those profits away from the companies. But the idea that the litigation, and there are at least 3 lawsuits so far, one settled, which we talk about in our paper, which is the Thermo Fisher lawsuit, but 2 of them survived a motion to dismiss, and that's part of what we were arguing in amici briefs, the idea that these lawsuits deserve at least a moment in court because many of the defenses that are being made do not track what the Restatement Third of Restitution says, in that they say things like you absolutely have to plead a tort by itself. All 3 lawsuits list only unjust enrichment as their cause of action, and for the most part seek restitution-based remedies in the alternative, either a disgorgement of profits, I think they list constructive trust, but they weren't that serious about it, and injunction, various injunctive type of relief. And so we try to argue why some of the misperceptions, and we think that Doug Laycock's work would go along with that in disabusing lawyers or courts too of some of those misstatements, because unjust enrichment can be freestanding, can have its own remedies attached to it. Of course, the remedy, whether you call it disgorgement or not, that remedy by Burks and others has been said to be parasitic. You still need to have the underlying wrong of some kind. And here, if you're going to do unjust enrichment, we would have to do perhaps a deeper job, and we will do that, of explaining what it is that is so unjust. But again, reasonable minds could disagree about whether it is in fact unjust, what Doug described, what happened to Henrietta Lacks, or is it too long ago? Is it disconnected from the particular defendants that are being sued at this moment in time? Again, you'd have to look at the particular theories as they're pled by these plaintiffs and decide, is there enough? But part of it is figuring out in the modern era what it means to be unjust, or as the Commonwealth might call it, unjustified. Is it unjustified that some are sitting with these benefits and getting to retain them without having to share them or cough some of them up? And I think that's a question that should hit maybe a fact finder, that should hit, and again, we could talk about whether these are jury trial rights or bench trial decisions ultimately with that type of remedy, because sometimes it's viewed as equitable and sometimes disgorgement is viewed as legal in terms of whether you have that right. But we're saying that there ought to be that moment. And so then the plaintiffs would have to better define exactly what they mean about the wrong. Is the wrong going back to 1951 when Johns Hopkins did this thing to Henrietta Lacks? If you go down that path, you might end up thinking, well, that sounds like maybe conversion, taking of her body parts, right? Stealing of her body parts. But then you run right into the Moore versus Regents decision. Of course, that's just California, but that was in 1990. Many of you will know that well, where 4 of the judges on that court said there would be no there'd be no ability by a plaintiff to get any kind of profits for that when your cells are utilized and big profits come off of it, it doesn't belong to you. So there isn't really that property notion that could stick unless we decide to either disagree with Moore versus Regents, which I do recommend Justice Mosca's dissent. But let's say we do agree with it, and in fact, there's no property right, then I would turn to the fact that in that particular set of facts, there was still basic medical conversations that you would hope take place, like we're going to do some things, we're going to operate this way, and we're going to keep some of the cells and experiment with them. None of those conversations how many? 3? None of those conversations took place with Henrietta Lacks. So when I think about the conscious advantage taking that the restatement echoes over and over again, I think Maybe. I mean, maybe there's the conscious advantage taking at that moment. Now, we could say, well, but at that moment, maybe it wasn't wrong for doctors to do that, to take without asking, to not give her that full informed consent. We could go back and, again, litigate that moment. And then we can look to today when some of these Thermo Fisher, other scientific companies, when they were taking and buying, usually purchasing these cell line in question, the HeLa cell line, what did they know and what deliberate wrongdoing could they potentially have or not have? And we think that's an inquiry worth making. It's kind of like the idea that there's suspect provenance on a piece of art. It's like knowing that something might have been done, perhaps not stolen if you don't agree with the dissent in the Moore decision, but we would say at least with unsavory practices. And if you take something with that knowledge, could that amount to the kind of wrongdoing where we need to have the conversation about perhaps we could disgorge these profits? Again, whether or not that is taking us too far into the future or too far beyond the bounds of what the Restatement Third of Restitution had in mind, as if it's a thing or a person, we're encouraging at least the idea of these causes of action because it's refreshing to see a one count, and that one count is unjust enrichment. It's bringing something back into the public consciousness that perhaps had faded. It's getting a conversation on the table, perhaps for settlement, and successfully in one of the cases, and perhaps more, where there's a bit of a reckoning. Now, is that really the place for doctrinal law to do its work, or is that bringing something that's the unmoored morality or moored morality that the Restatement Third of Restitution would have real trouble with? We ultimately think there should be limits, and we talk a lot about that in the paper as well, and Professor Laycock's work about some of those limits of making sure it's net profits, making sure you prove the sort of causal links that are necessary, and that you prove the underlying unjustness. That would be something that would have to be done. But in the end, we hope that this at least gets the conversation out there to think about what are the proper limits to creative uses for restitution and thinking about gap filling, and maybe that's a good conversation to have. Thanks.
So we have probably a little under 10 minutes for questions or comments, and I can certainly ask one myself, which is I found, there are a number of interesting things here, but I think there's one question that a number of the panelists could respond to is I think this reverse causality point that sort of Rick raises about the idea that law can be generative of markets or as well as simply responding. And I thought, I guess I asked Andrew how he might respond to this because I wondered in your paper you have this idea of the sort of commercial approach developing, and it seemed like, this could be something you could analyze along these lines. Is this one where it's helping to generate the markets, or it's simply responding to, say, the established already established business practices and understandings?
Well, I mean, on these pages here, which I just ruthlessly omitted from my presentation a few moments
You're a
ago.
very rude moderator.
I would at least have given a couple of the landmarks about, what am I talking about? The equitable approach. Yeah, you're unjustly enriched. You have to give back the money unless you can show, at one point people would have said a countervailing equity, but that's your change of position, your detrimental reliance. That's, I think, as far as it goes, it's fairly intuitive. And if you think, well, we're looking for unjust enrichment, and we're trying to correct it, it's almost self-explanatory. Where's this other thing come from? The Mansfield opinions, where at least for symmetry and for fun, I would say, hey, listen, he's got this in his mind. They're important 18th century decisions. One of them is, I think, one of the greatest decisions in commercial law. It's called Miller versus Race. If you pay somebody your debt in stolen money or banknotes, can the theft victim get it back? No. And Mansfield says, because if we allowed that, it wouldn't be money. He says it would not be currency, is what he means. And the other one, a famous case, less dramatic than that, but famous, it's called Price versus Neal. You present a check to the bank, It's forged. You don't know that. If you know it, forget it. But it's forged, and the bank by mistake pays. Bank's mistake. You had nothing. You had a forged check. It was worth nothing. Bank has paid you. Do you have to make restitution to the bank? No. Also, Mansfield, he is much less clear about why, and I think people have argued about it ever since. What's the rationale of Price versus Neal? It's very influential. It goes right into the UCC, and I mean, it's been there ever since. And so people think of different rationales. The more enlightening opinion in this line, I would say, is from Joseph Story in Swift versus Tyson. People think, some of you probably, I'm sure, have heard about it. They think it's a case about federal courts. Well, no. He did change the whole Federal Judiciary Act, but it's because he was so anxious to say, we are going to recognize a defense to commercial creditors who take money and instruments. We're talking about negotiable paper. And he says why. He not only says this is the rule in the federal courts, forget this about state law, but he says why. And I think it's the most concise explanation of why that there is. This is, 1840? And he basically says, it's not because of unjust enrichment. It's obviously not because of unjust enrichment. It's for the convenience and benefit of the commercial world. They have to be able to, well, just as Miller versus Race, they have to be able to treat money as good as gold, and they have to be able to treat their negotiable paper as if it were money, because otherwise all sorts of regular routine transactions will be disrupted. And, there's various ways to put it. I think it all comes down to what he says in 2 or 3 paragraphs, which are in here if anybody wants to read them. So that's what was going on in Swift versus Tyson, and that's why they changed the whole Federal Judiciary Act, because he was not going to sit by and let Chancellor Kent in New York say that these commercial payees did not have, solid title to the stuff that had been paid to them, as a result of fraud and so forth, because that was what was going on.
Any questions from the audience, or do you want to comment on these points?
Super quick. There are all of these great empirical articles that are looking at contracts that sophisticated parties are writing, and now they're doing it with machine learning, and they see it begins with John Coates in the late 80s or 90s, early 90s. And all these deal makers are stipulating specific performance. So that's when I learned about it. And I just thought, oh, these are really sophisticated parties. And then I later learned it all happened because of what Leo Strine did. So it was the law that generated the practice. And I think mergers and acquisitions work in a different, maybe more fluid. I don't know if it's more efficient, but really the law was generative of a whole new way of putting these deals together.
Doug.
So this is not about me. This is about Andrew. When he got pressed for time, he never told us what his new solution is. His new solution is. It's brilliant. If the payment is in the ordinary course of business, the creditor gets to keep it. And if the payment is irregular, the creditor has to give it back. So nothing was more irregular than the Citibank payment. They have to give it back. But if it's a payment that was due and that you were expecting, you get to keep it. And that is a compromise.
There's nothing weird about it.
It works.
Yeah.
And if I had been able to go into more detail, I would say, well, I do say in here, at least one could easily take the view that the Bank Worms decision from the New York Court of Appeals reaches the right result because the circumstance, like I say, this was not like Revlon. Everything was ordinary and unsurprising. And the problem, at least where I say there's something to talk about, is they just don't talk about it at all. Gee, there's these 2 lines of decision. They're completely contradictory. How did that ever happen? No, they don't ask that. They're not interested. And these are things that lawyers and judges in the 19th century, these were burning issues. They were very, very familiar. I haven't even talked about antecedent debt as value because that would take a while, although it's sort of interesting. But I mean, everyone knew about it, and by the time Bankforms comes along, it's now 1990. This is, it's far enough away that, gee, where did these two lines of decision come from? I don't know. I mean, that was their attitude. And yet it becomes much clearer. Now, what Doug is talking about is, I was thinking, gee, how could we have fixed this? And I think the most important thing is to put in, if it's in the ordinary course of business, which is a limitation that is in almost every one of these cases, including even Bankforms. Certainly in Mansfield, everyone always said, well, if it's payment in the ordinary course of business. Why didn't we put that in to the restatement? We weren't thinking. I wasn't thinking.
Put an inquiry notice?
Oh, yeah. Well, there's a whole lot in there about notice. And yeah, those two things reinforce each other. I think there's no question. But anyway, I'm sorry.
I think we've shown that you could talk about remedies and restitution endlessly. So with that, we're at time. So I have been told to ask everybody to stay seated for the moment by our true master of ceremonies.
Yeah, so one more round of applause for this panel. And I'll just wrap up today's event, and I want to be very clear about something. When this whole idea was an embryo, when Sam, Chris, and Rick had come up with the idea and they posed it to Dean Chesney, he asked me if the First Amendment Center would be willing to host this Festschrift. I was at dinner with Doug in the UT Club, which is in the stadium about right here. And it was a group of us, and I said, how do you feel about this Festschrift? And he said, it feels like we're having a funeral for me, but I'm still alive. So I want to be clear that what I'm about to say is not to suggest that Doug has passed. He is still writing and contributing at a very high level that I think many people would be envious of. That said, Chris Lund and I were at a conference together a couple years ago, and we were talking about how one of the problems in our field in law and religion is you struggle to come up with an idea, and you think through the doctrines, and you're pondering stuff, and you come up with something that you think is really original, and you climb this intellectual mountain, and you get there, and you're so proud of yourself, and then you look over, and there's a rock with a plaque on it that says, Doug was here. And so that, for me, begs the question, I think it's really appropriate that we're doing this for you, Doug. It is altogether appropriate to have this Festschrift and let you celebrate with friends. But I think for those of us in these fields, the best way we can honor your career in scholarship is to build on the ideas, the history, the writings, and the theory that you have developed, either by developing those things further or by disagreeing with you in a productive way. In short, we need to climb higher mountains because the mountains you've already climbed and are climbing. And thank you so much for making that possible. So one more round of applause for Doug Laycock.